this is a terrific group and it's a terrific event. I was asked, we thought about it, I'll give some short opening remarks, just I think to set the debate and give us some food for thought and actually consider why this, in a way, is a much more difficult problem than it seems, and I think it's important to reflect on that. So the inspiration for this conference started actually at the ASCOLA conference of last year. So we were in Würzburg meeting, and I met Ioannis, and we were like kind of like talking about, oh, what are you working on? We're working on. Then I was like, oh, I'll tell you something, but don't share too much around. But we're actually working with Tommaso and Luigi. We're working on a large project. They were trying to understand how does conflict of interest impact economics, economic research, not only antitrust. And then Ioannis said, I'm also working on this topic as well. I have a separate paper that I'm working on. And then by the moment we started talking about it, I realized we were almost like in a corner of the room, kind of almost like whispering. It was like almost like a topic that people didn't want to talk about, didn't want to reflect much. But it's an important topic to talk about. So if you can move to the next slide, please. I think that will. And then we're a bit surprised actually afterwards when we started working in parallel. We didn't know what we were working on exactly. But then quickly, I think it became a decanter delivery remarks talking about the specific, the issue of corporate relationships and how they impact academia, how they impact policy and antitrust. And this is inside a broader context where I think is important to keep in mind is that trust in higher education has been going down across the world and across the US, and that's something that we also have to keep in mind about this as a broader societal issue. Can you move to the next slide, please? And so I wanted to start my opening remarks talking a little bit about an article that I wrote with Tommaso, I wrote with Luigi, mostly to give you some data that I hope can help us instruct the discussion and take a bigger, broader picture view. So one of the things that we did in parallel is not focus on antitrust at all, is focus on economics research, that we try to understand how do different forms of conflict of interest, different forms of corporate relationship impact trust in academic research, right? And so we did this paper, which is basically a survey paper where we surveyed 3 different groups. So we surveyed what we call selected economists, like elite economists. All names are horrible names. There's a lot of discussion. They're all bad, But these are basically like tenure professors in like very high end universities. We also survey what we call the ordinary economists, so like PhD economists who are producing and consuming economics research. And then we also surveyed our average Americans through a YouGov pool. And we tried to understand the structure of the survey was basically we will give people the conclusions, broad conclusions of an economics paper, and then ask them, okay, how much do you trust the results of this article? And then we basically give them a disclosure, a proper disclosure, saying the authors have properly disclosed one specific type of corporate relationship. How does this impact your trust in the results of the article? And that's basically what we're trying to do. So we have a couple of different vignettes that I think are relevant for today. If you can please move to the next slide. So one of the first vignettes that we had was actually focused and inspired by antitrust policy. So basically the idea was like we have this paper that basically concludes that a supermarket merger, the merger between large supermarket chains either increases or decreases welfare. And then we asked them how much you trust the results of this article. And then afterwards we disclosed 2 things. We said, and then afterwards you're faced with the first, basically a treatment where you read the first footnote of the article, and the footnote reveals a couple of different things. So it could either reveal that the author of the paper was a public expert witness in a merger litigation for the DOJ against a specific merger, or was actually a private expert witness against a specific merger, and it could mention basically the person, not mention how much money the person was paid, or could actually mention $400,000. And we could see here is basically what is the trust reduction, so how much do people, the different groups, react to the different types of information. And I think what is interesting to see is that there is a trust reduction for both public experts and private experts, though it's much smaller for public experts, so the type of employer, the type of relationship matters. And of course, the more the mention of compensation, the mention of money matters a lot. And one of the hard discounts that we have, for example, is if you're a private expert witness and you've been working, and actually people are aware that you got paid $400,000. And the discount, this is like the inverse, So this you should see like a trust reduction. So the discount can reach up to 35%. It's not a presentation about the paper. I don't want to go into methodology too much, but basically like this is across the board. It impacts average Americans, ordinary economists, and also what we call selected economists and elite. So if you can move to the next slide, please. So we did this for different configurations. So another thing, we had a vignette that was about a trading strategy. And in that vignette about trading strategies, we basically said, no, there's this paper talking about the profitability or the success of a trading strategy. And afterwards, you learn that the person who wrote the paper had either received a research grant or a consulting fee associated with that paper. and this research grant and consulting fee paid this person $10,000, $100,000, or $1 million. What is interesting to see is like the discount between research grant and consulting fees is very similar. Like it's almost not statistically significant. So structuring these relationships as a grant versus a consulting fee does some work, but doesn't do all the work. And in a way, money matters much less than we initially anticipated. Like the difference between 100,000 or $1 million, which I think is huge for practical purposes for a specific person, is actually not that large in terms of the discounting that goes is around 30% for both. Can you move to the next? What is interesting, though, and I hope we also keep that in mind, is that what we also try to do is to understand what about data relationships? Like we talk a lot about money, we a lot of the time ignore data, what data is doing. And so we had two different vignettes that touched on data. One that looked at public data. So basically the idea is like, this ride-sharing company enters a city, and basically there's a paper studying the impacts of the ride-sharing company entering the city, and the company can either, the paper can either conclude that the entry of the ride-sharing company improves welfare or decreases welfare, and it was beneficial or bad for the city, and the paper can either use public data made available by the city government or private data supplied by the company. And what you can see there is actually the use of public data, publicly available data, actually increases trust in the conclusions of the paper. Well, on the other hand, private data decreases trust on average, but this really depends on the direction. So on the one hand, if the private data basically conclude that the entry of the ride-sharing company to the city was negative, then people, average Americans discount a decent amount, but experts discount very little. But if there's an alignment between the interest of the company and the data being provided, the discount is actually quite large. It goes to 20, 21, or 23%. And we are kind of like, we expected that this would be somewhat connected to private access to data, like the terms under which the data was supplied. And so we had a separate vignette where we talk about the efficiency practice of a credit card company. And so basically we are in a world of private data. And we said, the paper used to study the efficiency of this credit card company could either either the company waived off the rights to review the paper, or it actually enforced the rights to review the paper and said, I'm only going to give you the data if I can actually check the results before you publish it. And once you waived off the rights, basically, trust increases by a significant amount. But once there's an enforcement of the rights of access, actually, this is the largest decrease in trust that we see throughout all our vignettes. So in a way, data is even more important in some ways than money is for this type of relationships. So a lot of what we're going to be talking about is disclosure, right? What our results show is that basically people can unilaterally deviate from this equilibrium by disclosing, by saying, the company waived off the rights to review the paper, and therefore we solve a lot of the problems with conflict. So one of the things that we did in this survey is that we asked people, have you actually adequately disclosed your conflicts of interest in the past? And the vast majority of people say, yes, we have. But then we asked them, okay, and do you believe that your peers have adequately disclosed at present? And everybody basically says no. Okay, so I think it's important to understand that, I think that our disclosure system, that's something that we're going to talk about much more, has some fundamental problems. And one of the things that we try to do is try to look at how prevalent are these types of relationships in current scholarship. So one of the things that we did is that we looked at all the papers published in the RAND Journal of Economics. We looked at different journals, but there's an antitrust conference. I'll talk about RAND, for example, which is the leading journal in IO economics. And then we looked at all the papers published there over the past 5 years. And there's a couple of things that you can see in this data here. So first, RAND does an amazing service to the profession. Aviv Nevo was an editor of RAND. Thank you. That RAND actually publishes a lot of papers by PhD students, PhD chapters. And these are great. These are mostly don't have any relationships. But once you go to empirical papers, which are growing parts, almost 50% of the papers had either direct data relationships. So the data used was like private, inaccessible data that basically cannot replicate the results. Or they're just employer sources, meaning the person was working for a company while writing the paper for RAND at the same time. And this is basically half of the papers, empirical papers published over the past 5 years. And this becomes more interesting. I don't want to pick on RAND and talk about it in a second. It's just like we're looking at economics or we're looking at RAND. It's like the RAND core policy, for example, focus only on financial arrangements, doesn't focus much on data. And he actually states that the information about potential conflicts of interest will be held in confidence while the paper is under review and will not influence the editorial decisions. So that's something that is interesting. There's a bit of a divergence to what we would expect in other conflicts of interest policy. So I'll finalize with 3 things that I think are important. So I try to give some data so you think about it. That money matters, the type of relationship matters, data should matter as well. We'll talk much more about it. I think it's an important conversation. But I also want to finalize by saying why I think this is not an easy problem, why we need to have this conversation. Just the fact that we're having this meeting right now and talking openly about it I think is a gain in a world where we haven't been talking about it openly. We need to talk much more openly to try to come up with a good diagnosis of the problem and a good area about potential solutions. So first, I think this conversation can very easily turn on a battle against economists, and I think that's not correct. I think that the same problems that exist in economics, potential problems, exist in law. I'm a lawyer, I'm not an economist. It started in law, actually. Lexicon was created by 3 legal scholars at the University of Chicago who basically saw the rise of the law and economics movement and then created lexicon. That's why it's called Lexicon. No, that's the name of the area, and it's actually quite pervasive. I really honestly believe that this should not be a conversation about personal ethics, but it's a conversation much more important about systemic incentives. Like, this should not be about name calling. This should not be about trying to find culprits for whatever has happened or is happening in antitrust policy. Because many scholars are well-intended. I think it's hard to disclose many times, and also this is a very large market, but we need to think about the growth of this market. Like, I've been at Georgetown since the summer. I received 2 invitations and I declined to be an expert witness over the past 6 months. Okay, that's something that's happening. There's a broad market, there's a broad conversation. And I think, like, once we start thinking of this about the systemic incentives, as Ioannis has his paper, is great about talking the negative or positive externalities that come out of the corporate academic relationships. I think everyone should read it. Once you start thinking about these as systemic incentives and the incentives generated, the externalities generated, becomes a much more productive conversation. And I think the final thing I want to say is that there are also many benefits to corporate academic relationships. So this is not an area where, like, I think a ban is warranted at all, because in many ways, in many practical areas, if you're writing about antitrust litigation, having experience in antitrust litigation is actually an asset. It's not a downside. If you want to go to court, how courts work, that's an upside. You want to continue to maintain that in antitrust and in other fields. Science is more expensive. I'm from Brazil. Many countries don't have adequate funding for science, so in a way, if you're going to try to ban these relationships, means you don't do a lot of research, and that's also an important thing to keep in mind. And finally, in the absence of mandatory access to data, and that's why the DSA is so important, and I think we need to talk more about that too, we also lose important knowledge if we cannot collaborate with private data suppliers. But this is just, again, some food for thought. I think I'm very happy with the panel we put together, the 3 panels. We're going to first discuss about what is the size of the problem in academia, how do we think about these dimensions of the problem. We'll then hear from judges and others, experts, how it impacts policy. And finally, we're going to incorporate academics, civil society, and others, and authorities as well in a 3rd panel to think about potential solutions. So thank you very much for taking the time. Some people came from far away coming here, and I'm really looking forward to our discussion today. Thank you.
Okay, so as the microphones are being set, I will start. I'm Tommaso Valletti. I'm very happy to moderate this first panel. Thank you to Filippo, Ioannis, for organizing this conference. It's a topic which is very dear to me. It's very important. So as you've seen, there are 3 different moments in the workshop today. We're going to start with some clarification of the magnitude of the problem. So if possible, but this is the speakers are people I cannot manage, but if possible, try to stick to that instead of the remedies of what to do next, because the remedies are for the last session, if possible. So we stick to, is there a problem to start with? I'll start just by giving a couple of minutes introduction. First of all, thank you, Filippo, for introducing our earlier research. I will add one more outcome from our research, just to make it clear to everybody. I think what's particularly important when it comes to research is that the extent of conflict of interest, which we do find in our results, we do find this conflict of interest discount that people trust less research, is a big negative externality on the majority of the scholars which are well-intended and don't have any conflict to disclose, because the average person doesn't know. So as we show in our work, people then are not sure if you're a good guy, a bad guy, and they don't trust the results much, okay? And this applies on average, so everybody is treated the same. So the lack of disclosure is a big negative effect on those which have nothing to disclose. And so this is important, because we are going through a moment where, to say the least, science in general is not well received among large portions of the population, and this is part of the problem. And this is part of the problem. The other comment I want to make, although I'm moderating, I cannot avoid to make some personal comments out of my experience. This is a topic which I've been thinking about for some years now. It's not new. It's actually, there is wonderful research on the tobacco industry. There's a book called Doubt is Their Product There is a Greek term called agnotology. So this is the art of selling doubt. The art of selling doubt from interests which are entrenched. So by selling doubt, it means don't fret, don't do anything different from what you're currently doing, which is just a reiteration of a system of power in place. So anytime there's something new, there's someone, just to give you an example of how important it was in the tobacco industry who knew well before any one of us that smoking is bad and smoking kills. We are aware of that now. But this is research. They basically bought in Harvard University. I'm not talking about some unknown university. They brought in Harvard University and very important professors at the time to say, okay, we need to study cancer. Can you please study the impact of air conditioning in offices in cancer? Because air conditioning is happening now. It's nothing to do with smoking. It's air conditioning in office. And there were big professors at Harvard that got millions and millions in research funds. They studied, they didn't find much, as you might expect. But also, they diverted their own attention away from what was relevant at the time, which was the link between smoking, tobacco, and cancer, because they couldn't have the time and the resources to do that. So diverting and directing research. And so there was this other narrative creating doubt, agnotology. My experience, which is limited only to a period of 3 years, from 2016 to 2019, when I was here in Brussels, I was, I shouldn't say shocked, because then people say I'm too aggressive. I was surprised to see how much pressure there is on a daily basis coming from, so lack of disclosure, a problem that we haven't managed. There was, what I thought was the most important thing was constant exposure to this agnotology, to these things, to every event happening in Brussels or in Washington, D.C., events organized by the big law firms, by the consultancies, to always espouse a narrative, everything is good. So there is very well-intentioned policymakers that listen from an audience which is telling them everything is fine, don't fret. And then they repeat those messages instead of asking more fundamental questions. So this I found a lot. I also found, especially, and it's not a critique of the legal side, but among the lawyers, an inability often to tell the good research in economics from the bad research in economics. Okay, so there is, for instance, as an academic economist, I know what is a good paper and what's just an afterthought, but shouldn't get any weight. Instead, it's about counting papers, not being able to distinguish something which has been peer-reviewed to something which is just uploaded on SSRN or something like that. And this was constant. But every time you would say, in cases in point where the research on common ownership was coming out, the research on killer acquisitions was coming out, the research on increasing trends was coming out. And this is stuff that got published very well in our economic journals, but then there was always something that was doing a counterpoint to it, not publishing ever that, if not maybe in some legal journals that perhaps Rupprecht may want to talk about, which are very colluded with this system, and then they were just counting. Okay, but this guy said A, but then this other guy said B. So it's up for some. So we haven't decided yet. So please do research. Come back to us 10 years from now. There was also, I see Giulio in the room. Our own. We got very burnt out with the innovation theory of harm. So this was doing Dow DuPont, etc. And we tried. And I think we did also an academic contribution to that, because it was an understudied problem, which was the relationship between innovation and mergers. And the attacks were quite unprecedented. And the lack of disclosure, and I've named and shamed, and I shouldn't do that any longer because then I'm seeing as, again, too controversial. But the way also some people and consultants and some academics reacted was not acceptable in my view. Not acceptable, and so this has directed my views. I will finish by talking more about academics, because that's where I am back. And this is when it comes to the approach of academic, and I will limit to IO and computational economics. I would say that by and large, academics belong to one of three categories. The majority of the academics are unaware of what's going on. Okay, this is the majority of them. They have other incentives, which is fine. We have our norms, our culture, and our incentive to publish and progress in our careers, which are dictated by other things. And they are not participating to an active policy discussion. That's fine, but they're just not present. That's the majority. And then of those who participate, I think there are two types. Maybe there is a degree of differences, but these are exemplifications, of course. One type is what I call the naive economist. The naive economist is somebody who takes an instruction as an intellectual challenge to produce counterintuitive results. We are trained as economists to do that because, our two hands on the warp. So I can always find a model that tells you that something which is very bad in general can find some good impacts in some instances. So this is what we do. We are trained, and that's a problem of my field. And so these guys, they just take the intellectual challenge. They have no idea whether that intellectual challenge is related to a case or not. They don't have access to data. They're just instructed, can you please produce a counterpoint in this direction? And if you're a reasonably good economist, you can do that. Typically, these guys, they don't see the bigger picture. I call them naive for that reason, and they are cheap in the sense that they don't ask for a lot of money. 10,000 euros, and you get a paper that actually, which is not much given the amount of money which are there. Maybe 20,000 for some people. And then there are the old foxes. And the old foxes instead are people who know exactly well the game. They are very expensive. We're talking about millions. We're not talking about 10,000. We're talking about millions. They've been running this game for years. They're very effective. They're very good at that, and that's why they're paid a lot of money. But they know well, and they are more difficult people to deal with. So this is where I stand on my side, very idiosyncratic on the magnitude of the problem. I think it exists, and it's very relevant. And I've also found, and this is, again, my personal experience, a sort of reluctance, if not an aversion, coming from competition policy circles to anything that is new. Any new idea, any innovation coming from, could be civil society, could be from academia, etc. The initial reaction is never how interesting, okay? But which I think, as an academic, when something is new, I say, wow, I want to think about it because that's new. Okay. Instead, it's always no. This is something that we shouldn't. We don't have any case history about it. Let's wait. So come back in 10 years when your research is more conclusive and tell us about it, which means, your research is dead when it comes to the policy impact. So I think I've said too much, and I want to start now with the panelists. All of them. They represent different parts of this business. They represent the regulators, enforcers. They represent former consultants, the legal side, and an academic that was also a top enforcer in the US. I'm just going according to distance, if you don't mind. So I'll start with Hans Zenger, Chief Economist team, a very good friend, and I would like Hans to tell his views about this problem about conflict of interest. Thank you.
Thanks a lot, Tommaso, and thanks a lot to the association for inviting me. I'm very happy that I'm on this panel because, obviously this is not a new debate, not even in the academics field. And we had a debate at the Association of Competition Economics last year, and people were asking what would be a good starting point to have better disclosure rules. And I pointed people to the ASCOLA rules and said, look, guys, you don't have to reinvent the wheel. Look there. This is a very good starting point, and then you can build on that. So let's see where that goes. But I'm very happy to be here for that reason. In terms of academic invited research and the possible biases that can bring that, I think I will start simply with an example. When I was a young economist and starting my work at DG Competition, so this is quite some time ago, was my first year as an economist. I was assigned to work on interchange fee cases, so MasterCard, Visa, that sort of thing. And we are about to raise concerns against the interchange fee agreements, but the literature was kind of on the one hand, on the other hand, and the leading paper was a paper by Jean-Charles Rocher and Jean Tirole, who later received the Nobel Prize, as you all know. Now, that research was funded by Visa, And so the model is not a bad model. It's actually a very illuminating and great model that later built on a lot of stuff, including the regulation that came out of these markets. But it's a very complex model, and like many models, has sort of some ambiguous welfare properties. And so it's a lot about how you describe actually what you're seeing in the model. So the model is just fine, it's not biased or anything, but the description of the model is a different thing. So at that time, all the banks and the credit card associations, they used this research and said, look at this. These famous people have shown it's all, ambiguous. You don't know what you're dealing with. I remember one meeting where we were sitting there and, the guys from the association were telling me, look, the system will break down. If you regulate the interchange fee, the whole banking system relies, and I'm like, it's like my first year. It's like, fuck, what am I doing, It's like, I pull the plug and all of a sudden, basically capitalism is dead. And I was like, and they were so serious about it. So, and I was like, but I just don't think, why? I didn't, so we went on and we investigated. And so we decided to dig deeper. Now, then once we dug a little bit deeper, we found that what's the mechanism that makes welfare ambiguous in this paper? And the mechanism is that the interchange fee is sort of a collective fee, imposed on merchants and therefore consumers, which therefore in this paper kind of sponsors the issuing banks. And if they have market power, that will increase the output of the issuing bank. So it's basically like saying, well, if you have a monopolist, you should pay that monopolist a lot of money for having more output, because then the monopoly distortion of too little output will be reduced. Now, obviously, that's a crazy policy suggestion, right? I mean, nobody in their right mind would go to a monopolist and tell them, we pay you on top. We're not having a tax. You're getting a subsidy, for selling because you're such a nice guy. So that's obviously crazy. Now, of course, that's not how the model was formulated. It was formulated in very technical terms on the one hand, on the other hand.
But that was the substance.
Exactly, that was the substance. And so then what we did was, I thought like, well, actually the standard in antitrust is not actually social welfare. The standard is consumer welfare. So we looked at consumer welfare, which nobody, in this literature had looked at. And what we found is like, well, surprise, surprise, we find that under all circumstances in this paper, the privately optimal interchange fees that the banks will set is always excessive, always in this model. That's not me saying, it's just the funded research that's saying that. So, as a consequence, we went ahead, we imposed, a 70% reduction on interchange fees based on objective standards. Now, to the credit of Rocher and Tirol, they later published a paper where they showed all these consumer welfare results once they probably didn't feel bound anymore, by the contractual relation to Visa. I'm speculating here, I respect both of them. I have great, respect for both of these guys. This is not to say that these guys, in any way are sort of obscuring the public. They're very honorable people. But of course, when you have funded research, do you have an incentive to describe your paper in a way that's harmful to your client? It's obvious that you're not. So I will read to you how, in a policy paper, a year after they published their paper, they themselves described this result, which implicitly contains that consumers are always harmed. So the policy prediction is proponents of a regulation of the interchange fee must first build a theoretical paradigm that gathers broad intellectual consensus and demonstrate a clear market failure, show that the resulting distortions have a clear sign and a sizable impact on welfare, so not on the one hand, on the other hand, and propose a form of regulation that is consistent with the underlying theory and is better than non-intervention. So far, no such theoretical paradigm has been achieved. On the contrary, recent academic work concurs to establishing that there is no systematic bias in the interchange fees selected by cooperative networks. There is no reason to think that privately optimal interchange fees are higher or lower than the socially optimal ones. Misunderstanding the economics of the problem and imposing cost-based regulation would impose substantial distortions in the industry. So that's my example in my first year as a young economist dealing with competition cases.
So I cannot resist to make two comments to what Hans said on the credit card issues. First, there is a vindication perhaps of what the Commission did. There is a natural experiment after Brexit this now small country called the UK is outside the regulation of the EC. These interchange fees are not regulated according to the EC rules any longer. And since 2016, these interchange fees, the cross-border interchange fees, which are not subject to regulation anymore, went up fivefold. That's a large increase, and no impact on issuers, apparently. So there was not even a waterbed effect. So the other thing I want to say about the Rochet role, which is probably more relevant, and again, these papers are from 20 years ago. Norms in academia perhaps were different, but you find the disclosure of the funding from Visa and Citicorp. There were two funders, only in one paper published by them. One. Okay? Everything else is lost. Just because I'm old enough, I remember that where the funding was coming from. But if you read those papers, you don't even know. So if you want to debias yourself by reading that, that's just a pure academic result. And this is something that has to change, at least the disclosure explicit where things are coming from. Okay, let me go next to Cristina.
Well, how apt, because you're all very, very polite, and I can speak completely in an impolite way. Why not call it what it is? I mean, Hans is saying, great respect, great deference for these people, but yes, okay, but they did what they did, and the implications are what we just heard. I have a particular claim to fame around this, because indeed, when I was still a consultant, I was the witness for Visa in the High Court in the interchange fee litigation. I was for 6 days in the witness box being cross-examined or crucified over the Rochet role, which we indeed used as the total Bible, as the defense. Because of course, the Rochet paper with their intractable tourist test provided the perfect, albeit impossible to test empirically, the perfect basis on which we could say to a judge, but what's the problem? These fees are not too high. I remember this was such a defining experience that my kind of gradual exit from consulting, really, I dated from there. You dated from a time when you're sitting in the witness box and you say, I'm talking bullshit, and this is completely non-defensible. But this happens, and this is the reality of Rochet role. And notwithstanding the fact they're a great and Nobel Prize, I don't understand the deference when you actually realize what was behind it. Going to what I was going actually to say. No, we need to get over this deference to the kind of saintly figures of academics, because they are as corruptible and as corrupt as everyone else, including the consultants. So let's call a spade, or tell you what I really think. So, of course, as the former consultant, I'm here to cover my head in ashes on this panel, because, of course, consultants are big drivers of the problem. I have to say, and I hope this is something in my defense, that I think I've always been very explicit in disclosure whenever I was speaking on panel. I dare say the only consultant doing so, because consultants going on panel still speak as if it is the God-given truth. They do not understand the rules of disclosure. At most, they will say, I work for one side and the other side, so that means I'm fair. Okay? So you need to name names. You need to say exactly who your clients are, and this is applicable to consultants and, of course, to academics. But I think later I'll make, further points about what I think is more of a narrow question of whether the current IO research is biased. There is a much bigger issue in economics and in antitrust today. But sticking to that first point, when I first came in to this world, there was very much a sense that the academics were not in the game. It was the late 90s. There was almost no one there. And then we began to sort of see the siren calls of the US business model, which was a model in which academics were effectively leading as experts in court, and there was this kind of build-up of consulting around them. And that was the basis for the huge lobbying exercise that some of us really were involved in the late 90s for the more economic approach. That was one of the most successful lobbying exercises ever. And academics it was mostly a consultant push. Academics were still relatively out of this, but Indeed, going back to the visa case, there were signs that the smart consultants, the really smart ones, were understanding that what you needed to do was to bring academics in some sort of saintly capacity. I mean, David Evans understood that extremely well. It was him who orchestrated Toulouse around Visa and Toulouse around Microsoft. He was essentially directing Microsoft and Visa funding to Toulouse to write these apparently neutral papers, but they were funded and they did not clearly disclose. Then we had, of course, the developments whereby we had the first chief economist 2003, and Roller was there, and then obviously Damien expanded the team, and there was a sense which was already developing amongst consultants, that having academics somewhat as part of the team was going to increase the credibility of what we were going to say. Because, we are just paid consultants, but if you have an academic on top, like he's the Virgin Mary, he's going to be bringing credibility to the argument that you're going to make. But of course, the reality is that when you are engaging an academic, either to appear on your report or to write a companion report, there is a very clear sense that the report needs to be helpful. Okay, so the report needs to be helpful. That is the language. I've never had pushback on that kind of tone, and ultimately. It has been the practical reality, and I kind of consider that academics have been very much engaged in this game. They're not the victims of something. They're not being waylaid by the bad consultants. There is a common interest, which is certainly, there is a lot of money in it, and that is very much what's driven some very dubious positions that people have taken. And this was an issue not just for cases, but also for issues, because when the whole issue of digital platforms and business models started really becoming central, then you had clients asking for, can we find someone who's going to just say this is generally okay? An academic who's going to say that these practices are acceptable, and that is again not always difficult to find. You can find that, and you can find, of course, the classics. I know these papers backwards because the classic structure is one that always says. Well, I have this model that shows that when the platform is maximizing profits, it internalizes consumer interest, and so that's all kind of good. And then you don't really say that the effects on entry or app developers are bad. I mean, you don't do these trade-offs explicitly, you bury it somewhere, but there is a whole body of papers out there saying that this is true. Is it tractable? Is it easy? No, it's intractable and very difficult because we have the problem of Shillism, and when you are also faced with the fact that some of the other papers that are out there in academia are very clueless about what really happens in digital. Let's just not be fooled by the idea that somehow there are the consultants and their economists bad and the academics who are pure good. Because the academics who are pure also write a lot of nonsense when it comes to, no, come on, stuff that is not real, stuff that I've seen people going to testify in parliament and saying, I'm here testifying on marketplaces. I've never worked a day in industry in my life. So are we supposed to clap, to applaud and say, well, you're pure, so, you're more credible than the rest of us chopped liver. So I will leave it there and then we can continue, but that's the background.
Thank you, Cristina. So I think what's happened, and Filippo mentioned the important speech by A.G. Cantor last fall. He was really saying how academics engaged in consulting, which is fine, they should be experts, but they became advocates. And so by becoming advocates, they lose the credibility of the system. So we lost it too. Now I would like to go to Rupprecht. Rupprecht has the unusual role of being both a legal scholar, he's been working in competition policy for a lot, he's been an enforcer, he also a leading voice in competition law, in fact. So I would like you to tell us your views from the legal side, if possible. What you heard from the Economist resonates with you? Is it different? Is it the same? Is it a bigger problem? A smaller problem?
Tommaso, let me first do my disclosures. I have counseled in the past, so I'm not a virgin. I'm sorry for that. And I no longer do, not because I'm now on the high grounds of morals, but because I'm in the Monopolies Commission and no longer allowed to earn any money on the side. The second thing, after having done the disclosure, let me turn to advertising. ASCOLA, if you don't know that, it has been mentioned a lot of times. Thanks, Hans, for advertising it already. ASCOLA has instituted this ethics code a couple of years ago, I think 10 years ago already. Ioannis Lianos was the main proponent of that, and we have just decided to set up a new ethics committee to look into the issue. So once you've done that with the Economic Association, you can turn to our new paper that's out in a couple of months, hopefully, again under Ioannis' leadership, and we'll provide you with more to chew on. Now, three short points. I think there is a certain difference between economists and lawyers. The one thing that always strikes me is that, this is anecdotic, I've never done research on that, is that all law academics whom I know have bad feelings when counseling, while I have the impression that economic academics don't. So I'm not quite sure what that tells me.
The money is much bigger.
maybe that's the reason. Maybe there's something else in that. I mean, if you give a case to two lawyers, you know you get 5 opinions out of that, and everyone knows that. So it's not like this claim of this is an eternal truth or so. And sometimes with economists, I have the impression these are the data, this is our set in stone methodology, so this must be the correct result. And that's sort of a bit of a difference in the way I perceive these two fields. So in law, you know that it's only set in stone once Fernando or Wouter have spoken on it. Then it's true. But before this point, it's probably arguable. And everyone knows it's arguable. So it's not so much about this is the one model or this is the one theory that we have which holds true, or this is the one interpretation of the case that is true. But I think it's much more about 2 other things that have been touched upon today. The one is building narratives. I heard that first at one of your conferences, Cristina, when President Mund of the German Bundeskartellamt said, we can only win cases if we have built a narrative in society so that the judges believe that our case is morally legitimate or whatever. He said that at your conference, and I thought, oh, wow, I believe that, but I don't want to hear an enforcer saying, I want to build a narrative in society so that I can win my case, right? But that's probably the reality.
Why not?
Because I think that the lawmaking process is sort of on a theoretical, ideological basis is something which is pure and not driven by narrative, right? I know it's different in practice, but sort of I would want to see judges who decide because they think this is what the law tells them to and not because this goes down well with society at the moment. Now, building narratives often works with building voices in society. And whenever I've been approached in the past years, ever since I run a successful blog in Germany, it was more about buying my opinion. That was my impression than buying my expertise. So when I started in the field, when I was a young lawyer, I had the impression people come to me and want my expert opinion because they are genuinely interested in what I have to say on the difficult issue. Nowadays, when people approach me, I had the impression they want me to write on our blog that this is a good proposal or not, or that I say that to media. And this is something that really strikes me and where I really see a strong problem. It's the complete ignorance of media, general media, towards this problem. So I'm often asked to say a word on policy reforms or legal cases or whatever by German media. But no one has ever asked me, oh, are you affiliated with anyone? Or have you any strong views on that or so? No one ever asked that. And I know from a lot of my colleagues that they never disclose or never refuse to comment if they are asked by media. And that means on the next day you've got that in Politico or Amlex or wherever, or general media saying, Professor XYZ says, oh yeah, that's a good idea. And actually he's been counseling Amazon for decades. So building this narrative, I think that is important. And for that narrative, you need important voices who are present, who have successful LinkedIn profiles, things like that. So that's a point that I wish to sort of, or where I hope that we find something for that. The second point is that I wish to make, for lawyers, it's not about the money so much. I think it is about the money, of course, but we should also not ignore that it's also about the niceties, the sweet talk, hearing the arguments of parties that really get your mind. So if I counsel for someone, I'm usually in touch with them in a partnership for for a year or so, or even for longer. And of course, I'm exposed to these very nice people, right? Sometimes they offer to do seminars with my students. My students love that, going into a company and seeing, oh, wow, they have a candy bar at the big tech firms. Why don't we have that in class? Stuff like that. So you build, and then you listen to them and stuff like that. So I think this is also important because it shapes your thinking a lot. And it's not just sort of you get money and then you're bought and then it's a one-off story, but it's often a much longer thing. The third thing, finally, what I think is really important is the asymmetry that builds up here. And one of my heroes in German competition, or Ernst-Joachim Messmecker, many of you will know his name. He's been a leading figure in the antitrust movement for decades. He once said, you can always counsel, but never for a dominant company. And I think what he meant was, if you counsel for the smaller ones, that's sort of a better cause in the sense that the others can buy influence anyway. And this is something that is, in my view, so important for this debate. I see this now in the Monopolies Commission where I am. And Tommaso, you actually said that when you said no one wants reforms, or everyone says it's difficult to have reforms. In the Monopolies Commission, we are an advising body for the German government, but with some statutory functions. The discourse is shaped by those who speak up to us. And who speaks up to us? The regulated entities and big tech. They are coming every day offering a new policy paper, a new study. They have thousands of people coming to us, or who want to come to us, and never ever comes anyone from a small, medium-sized enterprise or from a startup or anything. If they come, we have to teach them first what we are actually doing and what competition is all about, etc. So that's a complete asymmetry of things. And this is the place where academics can play a role, because they are sort of the ones who can give a voice to those who don't have a voice in this discourse. So when we discuss this topic, I think it's important not to sort of say, in the very moment you take the money, you're corrupted and everything's gone. I think that is part of the problem. But we really should focus on what does that make with the discourse. And public discourse currently is shaped, I think, by those who can buy the voices in public discourse. And that is, of course, those who have the money to buy that. And that shapes then the path of what you work with. So if we listen to the arguments of big tech firms in the Monopolies Commission, or big telco in Monopolies Commission, so the one big telco in Germany in Monopoly Commission, we are on that argument. Sorry for that. We listen to that argument, and our discourse, our recommendations also are shaped by what we hear from them. We first have to go over that mountain before we can come up with new stuff, right? And that is a real problem. I leave it at that.
Thank you very much, Rupprecht. I think it's important to, as you've just done, to remind ourselves that for decision maker, because obviously there's lots of asymmetric information, and decision makers have to pull information from different sources. And one of the problems, since we are identifying the problems, is that you hear only from a few voices, for too few voices. So again, going back to my idiosyncratic experience, we were doing, big mergers in steel, which has a lot of impact on workers. We never spoke to the unions. Okay? If anything, the unions would come to us at the end of the process where there was a remedy, and then they would have views about, but at fait accompli, after the case. So speaking to the unions was not, and I don't know if now it is part of the job of authorities, speaking to civil society was not part of the conversation, with a few exceptions. Speaking to startups was not part of the conversation. So what I think, and then I'm going to go to Aviv, has been particularly relevant in the attempted new Brandeisian revolution in the US was not just about the quality of the cases that you guys run, but also the language that you started using, the fact that Cantor and Kahn were going to, high schools in the middle of nowhere trying to talk actually to people which are not typically in a position of power, and trying to understand how they relate to competition issues, which I think, and this is since there are enforcers in this room, this is a period of democratic deficit for enforcers. There is a question about legitimacy of the enforcers. You are under attack. It's easy to attack the regulators. You got the Doge project in the United States. I think this is coming our way too. you have to show results which are meaningful for citizens, because otherwise, I mean, I wanted to defend you, but if you cannot show something which is tangible, you cannot say, well, we divested, what was it the other day, 3 tiles shop in the UK for a I mean, you cannot do that.
This is,
I
you
mean,
can talk about
anyway, later. So, but it's important also. So this is a wake-up call and listening to this wider society is crucial in order to understand what is important for the mission of a regulator, in my opinion. So, but Aviv, you've been living through this, I call it attempted revolution, but you're top academic, top enforcers, you've been a consultant, so you know it all. What's your view?
So let me first start. I was going to start with the disclosure, although I think you gave half of it right there. So I'm an academic. I'm an ex-enforcer. I worked at the FTC for 2 years up to end of last year. I worked at the DOJ before that. I worked as a consultant many years, had many clients on different sizes, large and small. And I should also say, I guess I am currently a consultant, although I don't have any current clients in the sense that I'm affiliated with Cornerstone, but I don't have any current clients to disclose. I'm also from the US. I think I'm the only one from the US here, so I don't know, brings a US angle. So let me just start a little bit on this kind of last point. I think, Lena went to talk to a lot of folks. I don't think she ever talked at a high school, but a lot of town halls. So let me go back to the original kind of question. Is there a problem? And to be honest, when you first asked it, I was actually going to say, yeah, of course there is. Let's move on. But having sort of heard kind of discussion, having sort of thought about it, I mean, it's not as obvious. So let me start for the argument why there is a problem, what is the problem, and many of these issues have already been raised. And then let me try to throw out something out there that I'm not sure I believe in myself, but let me just try to argue against myself as to maybe there isn't a problem. Okay? So let's for a second, why is there a problem? And if so, what is the problem? I would really put it in 3 different buckets. One is the issue of disclosures. We've had a lot of changes in journals. I think Filippo sort of put out, the RAND policy that's been around for a few years. Actually, I don't think it was in place when I was a RAND editor. It came out, after that. And I think that's a positive move forward. I think there's still issues as to whether we need to tweak it a bit in terms of what exactly it covers. For example, it doesn't cover grant money. As you pointed out, it's not clear if it impacts the process and so forth. Besides that, I think there is a much bigger problem on, panels like this one. I mean, not this one in particular, but panels like this in conference where I think the norms are completely non-existent, right? I mean, people say you have to disclose, but they don't tell you what you have to disclose. Okay, how many years? What exactly do you have to say? I mean, you say, I worked for company X, but working for company X could be, yes, I was called to testify to support some model that no one believes or I didn't believe or something like that. It could also be actually exactly the opposite of sort of saying, much of work that I've done for consultants, I actually used to joke that I blocked more mergers after I left the DOJ than when I was at DOJ, because I was quite routinely sort of contacted by folks who said, hey, do the exact same analysis you do at the DOJ, and we did, and we put it in front of them and said nothing. Just say, look, here's the number that the DOJ is going to look at, and they say, oh, wow, we can't get this murder through, and that stopped. And in my view, those are my favorite engagements because I think they're the ones that are most efficient, right? I mean, this cost the U.S. taxpayer exactly $0, right? Because this was a merger that was never proposed, never occupied the agencies, and I think the right outcome, was what happened, which the merger was, never happened. So how do you disclose that on a panel? I don't know, or in any other way. So I think, there's kind of big issues there. So that's the issue of disclosure. A separate issue is the issue that was touched on here is kind of questionable work that's been done in submissions either to agencies or to litigation. And I've been, at both U.S. agencies. I've been involved in litigation. And I've seen stuff that I think, Tommaso, what did I use? Shocked you, I think you said. I said, I've seen stuff that I was cringed by. I mean, it's I think it's a much stronger form of shock. I mean, there was stuff that like, literally, did they just say that? I mean, I must have misunderstood. You kind of go, and when it's in writing, you read like multiple times. I mean, really? Okay, I mean, are they that bad of a writer that they're not able to explain? It's like, and then you hear them testifying live and saying the same thing. I mean, it's awful. That being said, I do think we have to sort of realize that different people have different views. So I think putting aside any sort of corporate impact or anything of issues that maybe there's no funding at all, you take 5 different economists and you'll get 10 different views on topics having nothing to do with funding. It's just that's the way we are. We like to sometimes argue other sides of the story, and a lot of what could be happening is that you get the question is there a bias induced by the funding, or is there selection, right? If you're going to say, look, I want someone to support my position, and that's someone that's what they're in, that's what they believe in. And I know it's sometimes hard, having been in these cases, you sit there and say, how could they possibly think that? But they legitimately have a different point of view. I disagree with it a lot of times, but it's not because it's sort of biased, but it is something that need to think about. And then finally, even if there's full disclosure of the bias or not the bias, and full disclosure of funding, it does create a certain bias and help shape. When I kind of said, okay, there are certain views. I think over time, just it's kind of natural as a human being, you start and you say, look, I'm going to have a particular view, and yeah, maybe on the margin, I'm going to sort of say something because that's going to help me with getting this through whatever review process I have, whoever gave the funding. It might also help me get the next round of funding because I don't think. And then over time, you might start to convince yourself that that's really what you sort of believe in. And a lot of this is the kind of thing that when we talk about disclosure and stuff, the disclosure is backward. Right? I don't know how we could ever talk about forward funding. It's like, well, I'm here on this panel expressing views supportive to Apple because I hope Apple will retain me as an expert, just to pick on Apple as an example. But there is a lot of that, and I think Cristina nodding because that is kind of the case quite often. So I think those are kind of 3 buckets of potential problems. Again, I don't know what the solution is to them. I know we'll talk about that later, but that is something to think about. And I think some of these issues, especially this last one, potentially in the U.S. is going to become even a bigger issue. I mean, I'm sure you've all heard that funding for universities has been significantly cut. We don't know at this point if it's temporary because of NIH and NSF funding, but I can tell you U.S. administrators are, they're panicking. They're hoping it's temporary and goes back to previous levels, but they've cut, a lot of stuff that we usually, could do. It's now like, no, you can't do it. It'd be interesting to see what would happen kind of moving forward. And if you don't get public funding, well, I'm sure there's going to be a lot more turning towards private funding, not just, as consulting, but to support centers, support conferences, support things of that sort. So anyway, that's, I think, the case for is there a problem? What's the counter side? And you could say, well, okay, yeah, there's obviously a problem. What's the counter? The counter argument, I think, is something I actually heard from I was on a ABA panel, the ABA spring meeting, I think it was 3 years ago almost, with a judge, actually the same judge that ruled in the Apple case. And her view, and we had a lot of discussions before the panel, and at some point I kind of asked her, like, why don't you take a court-appointed expert, especially in a complicated case like that, to help you sort out between the bias and between, the BS and the real stuff. And her view was basically saying, look, everyone that comes in front of me has an agenda. Okay? I take that as a given. I take it as a given that they have a bias, they have an agenda. I need to figure out what that agenda is. Since for the party's experts, it's easier for me to figure out. If I hire someone as an expert, I don't know, with all these disclosures, whatever, I don't know what they did in the past, what they want to do in the future, what they want to do. It's I'd rather deal with the quote-unquote biased experts that I know the direction of their bias, and she's hoping she can de-bias their views or know how to sort of take it appropriately and push where needed. So that's the part of saying, like, maybe there really isn't a problem, right? We're sitting on these panels talking, but you should sort of assume everyone that's sitting on a panel has a bias, and if you can judge the merits of their argument, that's what you should do. And if you can't, you'd say, look, they're biased, I don't know in which direction, don't pay any attention to it. And when it comes to real work, submissions to agencies, kind of submissions to court and otherwise, the assumption should be that you're biased. And if you didn't disclose sort of what it is, maybe should be discounted even more. But I think that's almost kind of the way that, and it's not going to work, when you ask kind of the common person, but at the end of the day, what we care is not as much what the common person says, but what it happens in proceedings. So under that view, maybe there isn't a problem. And I'm not sure I believe that view, but let me just throw it out there to maybe get some reaction.
There is a problem.
So let me make a counterpoint to that counterpoint is that this would work. That is, there is, say, a neutral judge in the middle who's getting some information left and right, and they should debias the information they get. That can work in a damage claim case. So you win $1, I lose $1. So our incentives are the money we can put at stake paying the best consultants. The incentives are symmetric. But take instead something that matters, generally speaking, much more, which is a merger. So two companies are going to benefit from approving the merger in the range of billions. And then there are consumers. And these are people which are going to lose out, say, if there is market power issues arising from the consumer. Who represents them? Who represent them? Is it civil society? No. Is it BEUC, which we love, etc., etc.? But, I mean, guys, you cannot do everything. You cannot do everything. So there is a fundamental asymmetry there that the type of information that can be put in front of a judge is not a workout. So you have to impose some limits. I've done very little consulting practice, but I helped the CMA in front of the Competition Appeal Tribunal on some excessive pricing cases. I mean, and there was this thing of spamming the regulator, and the consultants would throw in report after report. I had the time to write one report because, why would I repeat myself 10 times? So, but instead they were sending and sending. So there needs to be a regulation. So there needs to be something, send a report of 25 pages. That's it. So we need to start doing these things because otherwise, again, it's an asymmetry of the stakes, which are so evident that this argument that there is going to be this independent judge. Well-motivated independent judge will hear, in different ways the arguments because one side is not represented. And the other thing which was important from Aviv and something we have to reflect upon, of course, we're asking for disclosure, but also this has to be somehow regulated, or at least there must be a common standard, because what I observe now, some of us have been pushing for many years for more disclosure. There is obviously a reaction from the inside, and there are people which are still playing this agnotology game. So they say we should disclose everything. We should disclose political biases because they are so important in policies. Let's disclose everything. Let's write 3 pages about disclosures. I've consulted for regulators, again regulators, etc. Let's put my CV up front, and then you're lost. So you really need to be pragmatic and say, I don't care if 25 years ago you were working for DG Comp or for the DOJ. What I care is what you've been doing in the past 3 years. And we're talking about competition. Your political views, fine. I'm interested when we go to the pub and have a pint of beer, but it doesn't really matter when it comes to competition issues. So we need to be very pragmatic on what matters. Instead of having this thing, and I've seen precisely those consultants that don't disclose in public fora such as LinkedIn saying, well, political bias is the most important one. Let's start with political bias, religious bias maybe. Let's do it. And this confounds the water yet again, and we go nowhere. Anyway, so
can I add something to that?
You can, of course.
Because I think that you are magnifying the problem a bit. It's not the question of, how far do you go in disclosure? You have to disclose everything you did, even behind the scenes. Come on, let's not be unrealistic. I think that I feel when I speak on a panel that I need to give the public, people listening to me, the benefit of knowing where I'm coming from. And that means who I've worked for and who paid me relevant to the issue I'm discussing in the previous 3-5 years. So obviously I've done lots of things that may not be relevant to the panel, but if I'm doing a panel on digital, it is a fact that I will say I worked adverse to Google, adverse to Meta, for Apple, for Amazon, for Microsoft. Do I need to say which specific case? I think that's going too far, but I think it is a matter of fundamental respect for the audience to say, these are the clients who paid me, I worked against these other guys, make of it what you will. So calibrate what I'm saying with this knowledge. I don't need to spend everybody's time for half an hour giving the full disclosure, but this is kind of what I systematically do. What people don't do is precisely this, because people will come on panels and say either nothing, or they will say, I've done both work for plaintiffs and defendants in this field, and leave it at that. And it's like, does that make you right on average? No, right? So that's the point.
So let me just kind of respond. So I agree. I mean, I wasn't suggesting that, but I do think that part of the problems we have with panels right now is there are no rules. And I've actually told, several conference organizers, kind of the large antitrust folks, it's like antitrust conferences, we should have rules. Just like the journals are very clear, and you might dispute about the rules that they have, but at least there's rules, right? And I agree with you, you should sort of say in the last 3 to 5 years, what's relevant. We have to kind of ask the question how we deal with NDAs, but that's a separate issue. I also would go further and say, if you're going to talk about a specific case, something that I've always followed, right? So I testified for Qualcomm.
Yeah.
Okay. If I talk about, and it's been more than 3 years, okay? But if we were to talk now about, any of the Qualcomm cases, I would bring that up because I think that's relevant. Right? If we're going to talk about the future thing that Qualcomm has done, we could decide, whether that's relevant or not. So it's not just about, but I think those rules need to be clear and written, and we can agree.
But the question is, whether we need anything. I mean, ASCOLA rules exist, and I keep saying they exist for the lawyers. Why can't we adopt something similar in economics? I personally think when I do a panel, I would hope that the organizer of the conference or the chair says, agreed that everybody here will disclose their conflicts. I don't need a great deal more than this, right? It needs to be some initiative that the conference organizer, the chair, needs to just put out there. It takes a minute, you do the disclosure, you move to substance. But we don't need to
No, but I think we also need to be clear about what does that mean? And that does not need to be listed to everyone, because some people will say, for example, they say, see my disclosure on the first slide, they say, go look at my website, which I personally don't like is you're right, it's exactly, there's too much information there. Okay, and B, it's on their website. I mean, I don't know about you. Yes, we sometimes pull out our phones during talk, but you don't want people to browse to go look on the website. They want to know what's relevant there.
Right.
But anyway, I think we've kind of gone into panel 3.
I was going to say, you're in the wrong panel.
So by the way, I'm going to ask more questions, but also if from the audience there is any question from now onwards, feel free to raise your hands and interject because I'm boring. Okay, I see. Go. Can you speak up?
But that's also panel 3.
This is panel 3, Todd.
That's panel 3.
Okay.
We have problems only.
We have to say more problems. We just scratched the surface.
Hi, I'm Helen Jenkins from Auxera. I advise MasterCard disclosure from earlier discussions, and Auxera advises lots of people. I won't go into all of it. The question I wanted to ask the panel is, we talked, it ended up being a lot about, in a court case or in front of a competition authority, what do people say about what they've done, what they haven't done, how that's going to influence how that particular piece of work is judged in that moment. But actually where the panel started, and I just wanted to get some more views on that, was actually about academic research. And Aviv touched on that, which is funding for universities, tenure systems, because, Tommaso, you're at Imperial, which has a lot of companies, a lot of pharmaceutical companies funding Imperial's research programs. So I just wondered what is the perspective on that question, which is what I thought was actually going to be more the focus of what do we do about that question, which is, are we getting the base research out there that helps inform Hans and his team, who are in that balance, whether it's the judge or the competition authority, they're drawing on that work that is done by academics, and our system has always been, through tenure and public funding, open research that allows people to look at the question from all angles.
Thank you, Helen. I should say that in the paper with Filippo, we actually even mention Imperial College as a case of bad practice, accepting funds in some. So I don't go only after the consultants. I also go after my own employer. Don't worry. But I know that Hans wants to say something about it.
So I think building on that, is there an externality is the key question, right? In a world where there's proper disclosure
let's assume that this world exists. Does the externality for research still exist in this world or not? And how do you think about the existence or not of a positive or negative externality here? So I think it's a perfect question to ask about going further.
So I think it's a very good question, and I think the answer is clearly yes. And the reason why has a lot to do with the biases that exist in academic research, even without any funding. So, and this is something that Tommaso touched on a little bit at the beginning, and Rupprecht as well. So, think about how academic economics works. What are the incentives? So, you want to write a paper that's relevant and that shows some new mechanism, but the goal is always to have some novelty. So you have some first paper which says, well, look, in country A we have this and this phenomenon. Let's say corruption influences trade policies or whatever. Now, if you then have a second person who finds the exact same result in a second country, that is really not very valuable research because it's basically something that somebody else has already done. So even though the learning for the real world may be very, very significant of this paper, academically it's not novel enough. You haven't done anything new. So the incentive is much more to find situations where actually the opposite occurs. So you have this whole profession all the time looking at some results which are out there, and usually, of course, the first results, tend to be the results that are sort of the more common sense thing, but then the incentive of all the young PhD candidates, they're all being told you have to find the opposite. So they do, and that's the incentive that is there in academic economics. Now, of course, that hugely biases the research process, not in terms of finding new mechanisms, because it's very good to find out new sort of theoretical mechanisms, but of course it hugely biases the research in terms of the policy relevance of that, because you're bound to find some things which can theoretically happen in some sort of obscure mechanisms, but which are completely irrelevant because they happen 1% of the time. And that, of course, is a situation where this sort of sowing doubt that you were saying, researchers don't need to be paid for that. They do it all the time just out of own initiative because the research process is what drives this. And I think this is a fundamentally flawed system. I will not propose how to fix that, but because it's panel 3 who will solve these questions. But the result is that you have all sorts of possibility theorems in research. So
Can I jump in as the academic? Why don't you finish? But I'd like to sort of...
Yeah. Sure.
Someone who's actually in the system and has been an editor and stuff, I'd like to have a chance to respond.
Of course. So what you have is, in terms of the relevance of papers for practical purposes, you have all these possibility theorems. So you have lots of reasonably well-published papers which show that, all sorts of sort of, very strange results. So firms can benefit from being taxed. Higher costs can lead to lower prices for consumer. Cartel can be beneficial for consumers. Innovation can lead to lower welfare and so forth. And that's, of course, fantastic. If you're out there and looking to contest some decision, in front of an authority, because you see on the one hand, it could be this, on the other hand, could be that. And then you have the problem that, especially in the theoretical economics, a lot of the people don't actually know the real world all that much because they're more interested in mechanisms than in policy relevance. So it also doesn't get checked by editors, in all cases in the way that it should be. Now, if you add to this situation funded research, of course, that problem gets magnified. And the reason why it gets magnified is because, if you're supposed to sow doubt on something, it just goes down exactly the alley of what you're doing anyway. So I think many of the academics who, have sowed doubt in ways that were not particularly helpful for the public debate, I don't think they were malicious in mind. For instance, the guys that were paid to oppose, Giulio and your research and the research by Emanuele and Massimo on investments. It's very clean research. It's like 99% of the cases, the case that you were describing holds. And these people, they get a little bit of money, and then they say, no. On the one hand, on the other hand, and of course that doesn't inform the public. That type of research, it doesn't inform the public, but on the contrary, it sows in policy terms a lot of confusions by focusing, on things that are, let's say, a little bit eccentric. And it's not a surprise, perhaps, that this literature has now converged pretty much into the same place. And I don't think that, now what you guys are saying and what the people who were paid to write papers at the time, I have the impression that you're more or less on the, on the same point now. I don't know.
I think no. I think the impact is structural, because if you read the literature now, you still, you used to get on the one hand Arrow, on the other hand Schumpeter. Yeah. Now you get on the other hand, my work with Tommaso, on the other hand, all these Toulouse guys, blah, blah, blah. So if you're a new PhD student or young academic, very often you see in surveys a very, on one hand, on the other hand approach. You have to read the papers, delve into the details to see that the 1% of results are one way, that's not another way. So I think it does have, it had an effect for 7 years. It's been diminishing, but I do think there is a long-lasting effect of that type of funded research.
Exactly. Especially in policy circles, because the same authors that you said produce clean research. I mean, I have personal views about that. At the same time, as they were trying to do some research, which was actually inconclusive, they were producing also some papers that got published in the law and econ journals, which don't have any proper academic refereeing, saying what Giulio, Tommaso, and Greg are doing is totally wrong, etc., etc. And this remained there. To the extent, because this has consequences. I mean, I care about my academic reputation, but I care about cases more, that competition authorities became, very risk averse to venture into those cases again. So you have, I've seen consequences of that. But anyway, so there's Aviv that will want to say maybe something because he wanted to respond to Hans. There is Rupprecht, there is Simon, there is and Cristina. So,
I just want to quickly.
You don't need a moderator, just go for it.
So the original question is there a kind of externality, and there's other forms in which, and here I agree with Hans. The answer is yes, although I will disagree somewhat on the mechanism. I hear what you're saying about the incentive to publishing. I've been hearing this for a while. But you also said the system is totally broke. Let's be very clear.
I didn't say this.
You did say the academic system is broke.
I said there's a bias in there.
No, you said it's totally broke. We can rerun the tape and see that. And let me be just very clear. The academic system does not exist to support competition authorities, okay? Despite what you might think believing in this room. So the academic publication process exists for a particular process, and the question is it useful for the kind of policy issues that we're looking at? I do think in the academic journals, and I've actually told this to a lot of folks, is once you're in the top journals, yes, the company is always to find something new and contrary and the opposite. I do think that once you go to kind of field journals and sort of below that, I think more useful in those journals will to be exactly the second, third, fourth, paper supporting certain results that could go, it's like, yeah, there was a positive result, maybe the first one that you said, let's find more support for it. It could be that. I think the real issue, though, is not that. I think the real issue in kind of thinking about the potential kind of externality and bias would be sort of in terms of, the direction that people necessarily go, and in terms of, funding and the way that it sort of goes. I think that's what ultimately. I think that's where you're going to get the externality. It will just kind of pull stuff, and it's not just about the funding; it's also about the data. Yeah. Okay, because a lot of times, like as an empirical person, like I've received data from private companies, and a lot of times I can't disclose who those companies are. That was part of the agreement. I've never taken money. I've actually made it a very strict point to never take money from them. But when you get the data, and again, there's no limits attached to that. They can have the data, and we're allowed to sort of publish what it is. But there's certain data that you get. So, for example, suppose you want to study what's the effect of privacy regulation. Okay, what effect would that have? Well, a lot of what we know, the effect of privacy regulation on, let's say, advertising, comes from experiments that have come from Facebook data. Okay, and they tend to be one-sided. Now, maybe that is kind of the result. I don't know. It's just that we don't actually get to see people freely sort of getting the data to experiment. And in that, it's not even funding that's creating the bias. It's really just the availability of data and willingness to do, even if there's zero funding attached to it. I don't think that we get, here is what we could get if we literally sort of get all the data in the world and give it to the academic world and get to see what.
But of course no one wants to give you the data because they want the control of the output. No company will give any academic any data unless they sign that they have control of the dissemination of the output. That is the reality.
So I think there's a rule number one in expert, never make, definitive statement. That's incorrect, because I can give you examples of data sets that we got from companies with no strings attached.
Okay.
Okay, but these are maybe not
in big tech. that are...
Yeah, these are, I don't know if they're technical. I mean, well, you guys know the papers I've been working on. I mean, Tommaso has discussed them in many times. I can't disclose who it is.
I would have to read them, actually.
They haven't been published yet.
But Tommaso, if I may, just a couple of small points. The first is, I think that focusing on academic research alone doesn't cover the problem, because I don't know any system where there are not completely blurred lines between all kinds of trades. I mean, we often work with lawyers. Lawyers are teaching at universities and dual roles, etc. That's basically everywhere. And that's this. I don't know a single economic who's not attached to some research company or whatever. So I think it's difficult to really separate these two issues. Just sort of Helen as a remark to what you asked. But having said that, I think two mechanisms that I find interesting also and to mention here. I think the one is usually if you're a call to the witness stand, or if someone asks you for a public opinion, for an expert opinion, you're usually someone who is already a bit established in the field because they want your name. That's sort of my assumption. Now this person then gets sort of known for working in energy company competition law, or energy competition law, whatever. That draws people to this person, or people that come pursue the PhD come with a certain bias because they know the work of their supervisors and stuff, right? So I think this is an externality or a problem that I see. That once, I mean, I'm known sort of as the anti-big tech guy in German academia. So people who want to work with me know how they can please me, right? This is a good bias, I think, but it's still a bias, and that happens, of course, to the other sides as well. And this is something that influences the whole discourse, because people who spend a lot of money and therefore sort of form opinions, and not just form the opinion of that person, but also the persons attached to this person and PhD students who work for him or her. The other thing that I wanted to mention, or just briefly, is I think if we sort of relate that back to practice, sorry for getting back to practice for a second, is that we also have to see that the field became much more open to this in the past years than before. So the more economic approach, if I may call it like that, opened up the floodgates, in my view, to data-driven competition policy. And my perception from the German experience with the Bundeskartellamt is they are and German courts actually, they're pretty resilient to expert opinions because they just ignore most of that stuff, right? This is why they're criticized heavily by many people, but this also makes them to a certain degree more resilient than the European Commission or others who write 200 pages on some opinions, while a German judge, we have studies on that, how German judges treat economic expertise. Basically, they look at it and say, oh, they take certain assumptions. We don't look at that anymore because the assumptions on the first page are already wrong. So that makes a court or I would say less biased than another system. I don't want to propose that this is a better system, but this is sort of something that we should think about. Can courts, agencies, etc., do they have the time, do they have the resources to even look into that? If you have time limits on abuse cases, if you say you have to do this DMA case within a year, then you probably cannot go to these things in the same length as you do in an abuse case that runs for 7 years.
And it's useless. So I wanted to raise the vision a little bit, because what we've been talking about is, of course, the known problems of disclosures, the known problems of the way in which academics are weaponized or deployed in specific cases. The entirety of this discussion proceeds from the assumption that there is an unchallenged hegemony of industrial organization in antitrust. And this is something which I think is creaking even more as we go along, because the antitrust world, and this is something, again, which has become very clear to me as I'm sort of exiting the consulting side. The antitrust world works on the premise that there is an absolutely unchallenged hegemony of industrial organization, that the IO economists are the purveyors of wisdom. They are the only type of economics that is worth listening to. And I find this problematic at this point in time, because what are we talking about? All these issues to do with the bias of research that Hans describes are absolutely true. There is any number of possibility theorems that any number of consultants can use to make the opposite case. We can do this until the cows come home. But the reality is that in truth, IO has become the hegemonic type of economics because it suited a certain type of political and legal elite to remove the discussion away from common people and keep it at an elite level. So only the initiated can discuss this, only the people who are in the church can discuss this, only my economists can discuss with the CET, I can bring my economists to just talk the science with the CET, and normal people have nothing to do with antitrust cases. This is, to me, an incredibly disturbing feature of how we do antitrust, one which is coming really under incredible stress right now in the political economy that we live in which when you say to antitrust people, but you see what's going on? Do you see what's going on? The world's on fire. There's the second China shock. The Germany is sinking now. They pull the trigger and they go, talk to the hand. I do competition over here. Nothing to do with me. Side dish. And this is a problem. We maintain this as a complete closed church, and it remains so. That is why I think what Lina tried to do and the FTC tried to do is so remarkable, by opening up the listening to normal people. There were entire files opened up to normal citizens who could comment on issues. Thousands of comments were being had when finally the FTC opened up the possibility to people to actually have a view and an opinion. And Lina traveled the world from Vegas to PBMs to pharmacies in New York. Who has ever seen a citizen on the upper echelons of Turmadu? Huh? Who has ever seen a citizen? So this is, to me, the real problem. We, in antitrust, are completely captured by the IO elite. We continue to believe that they have a wisdom they don't possess, because I can tell you that every single case I've done could be this way or that way, and the lawyers come in and say, is it ready? No, we need to cook it a little bit more. Wait until it's ready. Come on. So the reality is that we give deference to these IO sort of gurus to lose, etc. Why? They're just as biased in a particular church. And people don't get a say in anything that surrounds us. So I think this, in a time when the political economy is so dramatic, we are essentially saying, no, we are not industrial policy, trade policy, what does it to do with us? No, we are doing competition. This is crazy. That's my pitch.
Thank you, Cristina. So there's many questions. That if you can keep the question short, we can take more from the audience. I know there is Simon Holmes.
Simon Holmes, yes. I set it down as a competition appeal tribunal, but more relevant to my comment is my fact that I spent most of my career in private practice, and also as I chaired panels like this. I was picking up on a point which, Cristina, you made, sort of touched on the point, that people will disclose that they act for the claimants and the defendants, as if that somehow made them neutral. Or similarly, in a merger context, they might say, well, I act for the merging parties, but I also have acted for complainants. That gives you no idea of real context, because I've heard people say that, and yet I know from knowing them from many years, from knowing their work, that they are totally in bed, say, with the big tech companies or with the big monopoly companies. You don't get a sense of that. And in the spirit that this isn't the remedies one, I don't know what the answer to that is, because otherwise you'd have excess disclosure or very lengthy disclosures. I did 87% of my work for the blah, 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 which isn't practical.
So, Yanis, I think you talked about different forms of biases. Obviously, we started with material bias, which would be money or data. Aviv, you mentioned ideological bias that might exist in some context. Cristina alluded to that with schools of thought, when to a certain way that could be ideologically driven. So what is more prevalent from both? I mean, material and more dangerous in a way. Is it material bias or ideological bias? In the way that ideological bias, you can see by basically reading the text, right, or the article. Material bias, if it's not disclosed, it's much more difficult to find out. So that could be a possible way to think about this. And then I was also interested about the question that Helen asked. I mean, we have this type of funding of research in natural sciences, and is it something different in the context of a regulatory science that we have been discussing so far, like the economics and the law of the competition and policy, than for natural sciences? Do we apply the same approach? Do we distinguish between the two, and which makes it more important for regulatory science to have higher standards eventually because of the normative implications that science might have in decisions of competition authorities and courts? So that's some of my questions.
Okay, so on the last one, and then I'll leave anybody to respond. On the last one, through doing the work with Luigi Zingales and Filippo Lancieri, we don't need to rediscover the wheel every time. And in medical research, this problem has been known for at least half a century. Okay, and they started so much earlier than anyone else. I mean, because maybe the incentives at stake, bigger things, the research funds to labs, the pharmaceutical companies. So, and they started regulating the publication process, the disclosure processes much earlier on than anyone else. So I mean, look at those guys. It's not that it's being ignored and they're still discussing about it. They found solutions that still we are not adopting. So there are solutions in the medical research which are well known. And there are good standards, and there are good standards there, and they are debiasing a lot up to some extent, not always successfully, but there is. So there were some questions. I don't know if somebody wants to react, but there's also a question from Max, I think.
No, it's Richard May from the OECD.
I'm sorry, I forgot the marks.
Nothing to disclose, other than we're writing a paper, so trying to find some interesting things to write about. In that mode, I mean, we spoke about panels and academia, two other sort of vehicles or mechanisms for potential sort of corporate influence could be sort of the revolving door or sponsoring of training programs. Just keen to hear any reflections on those issues, whether you think they're an issue or any examples to point out from them.
So, how many exactly? So, who wants to respond to some of the questions? Material bias, ideological bias, revolving doors, training programs. You don't want me to respond. I'm the moderator.
I can say one thing about revolving doors and more general. I mean, obviously, here we are there to discuss problems, but not everything is always a problem. So, for instance, the fact that some academics do some consulting, which grounds them in the real world more than the academic work would do, obviously brings great benefits. I mean, the fact that some of the chief economists have done some consulting before them makes them much more operational in cases very quickly. And so, matching practical experience with academic research, I think is a useful thing. And I think it has helped to make commission cases, merger cases in particular, much more tied to the actual reality, what is happening, and not going after some, weird structural indicator that is much easier to tweak in one or the other direction, but really go after the problems that are out there, which in most cases we couldn't do when we have an oligopoly situation where we simply need this evidence. Then the other thing is revolving door overall. I mean, I'm someone who's done that. I was at the commission. I went to CRA for 5 years, where Cristina hired me, and then, Tommaso didn't quite hire me, but almost hired me. So I started, right before Tommaso and the chief economist team again. And if we did not have the ability to hire people with experience from consulting, we would have a very serious problem, because we need the expertise. You cannot have regulators who just sit there and don't know how the real world works and how the other side is arguing. And of course, the same is true for lawyers. I mean, it's good that people work in law firms and then come to the commission. So that side, I think, is also there. I'm not saying that there cannot be a problem with revolving doors. Obviously not. But it's just to say it has two sides. And the last comment on something that Tommaso said at the beginning on the spamming the regulator. So, obviously the fact that there's this asymmetry in staffing is a huge problem. And I think, and sorry, everybody has said something about solution. Now I also want to say something about solutions. I think it would be, really wise, if if the support that authorities get in the public debate is bigger. In mergers, we have maybe 50 people working, 50 people, I mean, we have on phase 2 cases, we have perhaps 2 economists working. The parties will have 15, the FTC, I don't know, 10 or whatever. So, we're so thinly staffed because there's a wide perception in Europe that, bureaucrats are just useless and, it's a waste of money. But these are so important big deals. And, the staffing, and I'm not talking economists specifically, it's exactly the same with lawyers. It doesn't matter the profession. I mean, the respect should be there to be able to deal with these problems, because one of the reasons there are so many economic submissions is also that not they are spamming us, but that we are spamming them. Because when you only have 2 people working on a case, the only thing that you can do, because you cannot run all this analysis on yourself with including all the data work and the data cleaning and so forth. So what we do is we outsource it de facto. We say, look, guys, get us this, get us this, get us this, and then we check it. If we don't like it, we say change this, change this, change this. And for the consultants, that's very profitable. So I mean, the consultants can easily make on a big phase 2 with the horizontal mergers, whatever, 1 million, 2 million on market shares alone, and that's basically us telling them, well, look, you have this level of granularity in your internal data, but we would like to see, because the case team wants to test whether product markets are narrow, we want to see these market shares at national level, at regional level, for all types of product specifications. And if we had to do that ourselves, it would be absolutely impossible. So it's a two-way street in a way. So I'm a bit cautious always when you say, we have to limit the amount that they can send us. I mean, I'm leaving aside sort of the legal rights to, to defend it yourself. I think we also really need this, or otherwise, please, the public should make sure that we have more than, the money to have more than 2 people on a case.
Yeah. Richard, revolving doors are not a particular problem in Europe. Honestly, I mean, I've hired dozens from the Commission and they've been going back, and I have no question about their integrity and what they did. So I don't, I mean, as Hans says, it's fine that people go back and forth. I mean, heads of agency is a bit of a difficult thing, because that's, particularly when they go and work for the very company that was being investigated, it's tricky there. But, staff, I think there's no issue.
I'm a bit less sure about that, Cristina, because if you're going to work on a case interacting with, the parties, consultants, law firms, etc., that, you may be a reasonably ambitious person that at some stage you may hit, a ceiling in your career progression because you're not promoted, and then you're going to work for those guys because that's the only outside option. These are not academics that can go back to academia, and so the way, what's the harm? The harm is that you're never going to say something which is particularly abrasive towards a potential employer in the future. That's obvious, no?
I think my expression is actually the opposite. And I've seen it even with private, a lot of times you actually see folks who hired people who worked against them because, man, you did a really good job there. And I've seen the same. Like if you actually go and say, I'm going to, be soft, I'm going to ask you the soft sort of questions, people can evaluate quality, right? And when Cristina wants to hire someone, she wants, Cristina in her past wanted to hire someone, she'd want to hire the best people.
It's a killer requisition.
I also don't think at the staff level, frankly, we're talking not at the top agency level, there is going to be that much of a bias that's going to be, so you're going to be slightly nicer to the lawyers. I mean, the lawyers are going to be mean to you anyway. So I don't think that really makes a big difference to cases. I mean, I don't think that's a concern. As I say, heads of agency, it's a little trickier, because if you go directly from being on the front line of deciding cases against big tech to working for them, and I can mention names, then it's a problem.
I think the problem is still deeper. Sorry, just one remark on that. It shapes your way of thinking about things. So if you are in that bubble and you go to an economist consultancy, you start thinking as the economist consultancies think. And then you go to the commission and think that is sort of the path we have to pursue. This goes to what Tommaso said earlier. If you really want to break through, even the point you made, I mean, if you look at the dominance of I/O, right? This is a dominance that is fostered by revolving doors, by people working on sort of in the same thing. I don't see the value of research in looking at individual concrete cases and making the market share assessment, right? This is not what I understand as research. This is sort of practical application of what we have found out in research before. And this also goes to the sides of what Hans, you mentioned before. I mean, and Johannes' question, what is the value, what is the idea of doing fundamental research or of doing research at all? If a company goes to the medical department and says, okay, can you please research this issue for us because we want to do that pharmaceutical thing, that's a different matter from saying, can you please check these sort of on a very basic level, right? So I would never sort of encourage my people to work on concrete cases as part of research. They have to ask the big questions, not the small ones. The small ones are for you, which is, I don't mean that in a depreciating way or so, but that's not our job. And that is sort of, that is the big bias, or that is the flaw that I see when funding gets into university, that we turn away from the big questions, that we turn away from challenging assumptions that are made in these fields. And that is also the problem I see with revolving doors.
There's, I mean, of course, one question, I mean, one thing that always has puzzled me is, you know, you have lots of people who, you know, who are a professor, but who essentially stopped doing research for like 20 years or something like this. But they usually keep their professorship at, you know, at the prestigious university. And so in the public perception, of course, you have this brand, which is like you're the objective professor. When when in reality, you know, 95% of their income comes from other work. And that I find a curious thing. Final comment, just very small, little on your shaping the thinking. I think we've hired a lot of people from consulting, and my experience is that the people we hire from consulting tend to be the most interventionist. You know, because I mean, one reason is that they have seen, you know, basically the tricks that are sometimes played on the other side. So they sometimes have lower trust. And on the other hand, they're facing exactly this perception from people. So there's first the suspicion, oh, this guy was 10 years working for these guys who sent us these outrageous submissions. So basically these people have to prove themselves, or they don't have to prove themselves, but they may feel that they have to prove themselves. So if anything, you know, I have to talk them down and say, like, look, it's okay, you know.
There is this wonderful paper, I urge you to read if you have the time. It's called Ideas Have Consequences by Suresh Naidu and others. They basically analyze a program that happened in the United States in the 70s. It was called the Money Program, which was exposing judges to Economics 101. Really, really the basic things, markets are great, everything works, but like in a week. Intense in a week without going into the subtleties and things that matter in oligopolistic markets. That was too complicated. So, and they can show with very nice empirical analysis that exposing judges to this, you know, competition is great, everything is fine, the economy is just okay, there will be entry anytime there is market power, don't worry about it because the economy is going to be fixed by itself, has real consequences on the later lives of these judges that sentenced to death more often black people. They became there's lots of bad stuff that they actually did, and they show it casual, in a causal way, that it was exposing to economics, with one exception, just following the textbook of Gary Becker. They were very lenient on drug sentences. So, because Gary Becker says it's your own decision. If you want to have drugs, you're going to ruin your life, but it's your so they don't care about drugs. But for the rest, it has real consequences. I know there are lots of questions. We have to move on to the next session. I would ask, since there are 3 people who wanted to say something, if you can condense in a short point or short question, and then if there is any quick reaction, otherwise your question will remain unanswered.
Comment, Max Bank, I work with Lobby Control, Lobby Watchdog Organization. I just wanted to say, I didn't want to touch upon revolving doors today, actually, because more about academics, but just wanted to highlight our definition of revolving doors among civil society organizations. And if we talk about revolving doors, we mean changing from a public institution to the private sector. This is the cases we find rather problematic than the other way around. If you hire people from the consultancy sector and they do good work for a public institution, that's fine for us. There may be problematic cases as well, but they're normally far less problematic, just to clarify that. And
I wanted to highlight as well, there have been problematic cases of revolving door at DG Comp in high-level cases such Bayer and Monsanto was in the press, and I wouldn't neglect that here.
I mean, okay, here I have to say something. This is about this Bayer Monsanto thing. I think you guys do very important work, but, this thing is really, really such an unfair thing. This was a colleague of ours whose contract ended and who, because of his contract being over, afterwards had to go to a consultancy because he's an economist. And then he chose among one of the consultancies that are out there. Obviously, since he had previously worked for the commission where he could not continue to work, he chose one of them. The moment he started a conversation with this consultancy, he came immediately to us before even signing the contract. Then we all sat down with Tommaso, I think at the time, we had an explicit over and above with Giulio, over and above all the conflict rules that are there, made him sign a thing that says like, you cannot do anything, you cannot know anything. We took him out of even the unit meetings. So this is something, and the guy is the most honest person in the world. He's really the most honest person in the world. In fact, the moment he passed the concours, he immediately came back to the European Commission. And this guy got dragged into the press because he happened to go to a consultancy for which he had worked, where the work had stopped months before he even was thinking about applying. And then this guy ends up in Spiegel and all these things. And sorry, lobby control, sorry, Max, I think it's very important the work that you do, but this thing, this guy had to read, his mother was reading in the newspaper with these allegations with absolutely no evidence that he had done anything unto. I think it's shameful that this guy now has to explain to his friends why he's a corrupt guy that is all across the newspaper.
On this I should second. I want to second what Hans said. I know, I can even say name. I know Daniel very well. He did a great job when we were together at the Commission. By the way, he's a small fish, so don't go after. So we can start discussing about Carles, about Nick, about these other people, because these are cases that matter. But concentrate on the real stuff. Just to go for the scandalistic news, I don't think. Sorry.
We should not, because of one individual case, miss the big point, and I think the big point is entirely right. There's no problem with people going from the private sector to the public sector. So the argument of saying that the people who come from the consultancies are even the most extreme, that's not where the problem is. The problem is the other side. It's the people going after the public sector to the private sector. Because that influences how they behave. If you are a Deputy Director General for mergers and your next career step is to cash in a law firm or doing mergers, I think you will behave differently than if you are one whose next career step is just to retire or to become a full-time professor at university.
Agree.
Thank you. Is there any more? No. There was one more comment, and then we're going to finish.
A very brief comment. I mean, it's not in the realms of competition, but when I worked at the FCA on the wholesale investment banking supervision desk, people who wanted to work for Goldman would change their behaviour in terms of how they supervise Goldman to make sure that the nuances of personal relationships. Then they'd hop off to Goldman because they'd been quite kind as a supervisor. But yeah, that's the public to private, which is a real issue, and that's where I support Max on that.
So I would like to thank all the panelists, and thanks a lot to everybody.
Alrighty.
Easy to have a discussion here.
Yeah.